Good evening, everyone. Welcome to Holy Rosary Church. I'm Father Russ, pastor at Holy Rosary, and we're here tonight for the Holy Rosary Catholic Church Parishioner Seminar on how to pre-plan your funeral, including the funeral rite at your church, as well as with the funeral home. We want to thank Memorial Park for being here and doing this for us, and also providing us the lovely food. Feel free to get up and get yourself something to eat or something to drink and that kind of a thing. Now I'm going to introduce Alec Bowden, who's here, and he's going to tell you about the first speaker and what he's going to do, and then you'll see me again at the end as I talk about the actual triple funeral rite in the Catholic Church. Thank you.
All right. Thank you guys for coming, and I really appreciate you guys making it out on a cold January night to talk about funeral planning. I am actually shocked that we have this many people here for that exciting discussion. But it's going to happen to all of us at some point in our lives. And so being prepared for that is important. So I'm excited about the opportunity to talk to you guys. And I hope that I get a chance to meet each one of you individually. And we have a couple of things we'd like to share with you tonight. One is about Memorial Park and funeral planning, but also looking at the larger picture of things. I have a friend of mine that I know from what I do, and also I think, if I'm not mistaken, I actually taught him in school. I was his teacher at ECS. Out there on Macon Road, and I think I actually taught him in school at some point. So we found that out later on. You tend to grow up, and you don't think that people do, but we all get older. But James Stiles is an estate planning attorney and also has a title company along with that, his law firm. So I invited James to come out and share a few things about estate planning, and then I'll come along and share some things about Memorial Park and so forth. So I really hope that it's informative. I hope that you learn a lot. And we'll have some time for questions at the end, because there's always some things that come up that people want to talk about. So I'm going to turn it over to James.
Alan, thank you for that introduction. As he stated, my name is James Stiles with the Stiles Law Firm. This is not a fun topic, right? We all hear death, and it's people run away from it. But let's try to make it as fun as possible, right? There's two things in life that are certain. That's what somebody told me, right? What are those two things? Death and taxes. Okay. And change. That is completely true. And my motto is, as you age, your estate planning changes. So we need to adapt to that. Tonight I'm going to talk to you all about what I do, right? It's the estate planning process. All of us have an estate plan, whether it's good or not, that can be argued. But I'm going to talk to you all about all the documents that are involved in the estate plan, okay, during your lifetime and once you passed away. I've made a practice in my life, in my livelihood, that when you go through law school and when you go through practicing, I realized that how does this work in real time? Because that's all that matters, right? When we pass away, how does the last will and testament work? How does a trust work? How does an irrevocable trust work? So I'm going to step you through those processes. I'm a very visual person here, so I'm going to step you through every one of these documents and what they do, okay? And an example on each. So again, we call this estate planning, right? So I'm going to talk to you about the documents that consist of this. So when it comes to passing your assets, or the estate planning documents that we have in our tool belt during our lifetime, there's really just a handful of them, okay? There's a last will and testament, there's a revocable trust, and then there's an irrevocable trust. I'm going to try to go through this as quick as I can here, because I know we don't have all the time, but we're going to take examples with this. And again, I could spend hours on this, but we're going to talk about a last will and testament, okay? What a last will and testament is a directive. It states that when I pass away, I want all of my assets to go to my wife, or they better go to my wife, right? Then after that, it's going to go to our kids and so on and so forth. So let's take an example with this. We have Joe's last will and testament, okay? Joe states that when Joe dies, he wants all of his assets to go to his sister Anna and his brother Mark. 50%, 50%. So again, how does this work? And he has this executor. An executor is the person that executes the will. So we'll call him Sam, his brother. So what happens in real time, right? He's drafted this trust the attorney has for him, and he has all these things laid out. When he passes away, he wants to go here. What happens when he dies? So Joe, we'll say, has a personal residence. Joe has stocks. Joe has a money market account. Joe has life insurance and other assets. So what happens in real time, once Joe passes away, his brother Sam is going to hire an attorney, right? Because with this money market account, checking account, all these assets, they're not going to just give them over to the beneficiaries. They're going to make sure it goes through what's called the probate court process. So what happens is Sam would hire an attorney, open up a probate estate in the Shelby County, because if we have a last will and testament, or if we do not, we have to go through that process. He's going to get all these assets. He's going to put it into an estate account. And let's just say that, we have $500,000 here. In the estate account, he has to keep this estate open for a bare minimum of 6 months. In Shelby County, we have to keep an estate open for 6 months. We have to give specific notice to creditors. Even if we don't even have any, we have to keep the estate open for that long. And no distributions out of that estate can be made. And the attorney does that because even if we know that there's not any creditors, if there happen to be creditors that come out, we're liable on that. So we have to, the funds have to be held in the estate account for at least 6 months. Typical estates are 12 to 15 months. Anywhere between 10 to 15% of estate can be eaten up in probate court costs. So he goes through this whole process, and like I said, 10, 15%, maybe more, is eaten up in estate cost here. But what happens is Sam, as the executor, and with an attorney's help, is going to make sure that all these assets are distributed according to the terms of the last will and testament. And we have court oversight to make sure that $250,000 or thereabouts is going to go to Anna and Mark. Okay? That is the last will and testament. Now we have a revocable living trust. With the revocable living trust, we have the same example. We have Joe's revocable living trust. Joe has his house that actually would be owned by the trust, but Joe also has his money market account, his stocks, other mutual funds, other property, other assets he might own, and so on and so forth, just as we had in this example. Okay? In a trust, what the person who administers a trust is called is the trustee. It's the person that administers the trust here. That trustee is going to be Sam, right? The same person that Joe picked before. In a trust, just imagine having all of our assets in this basket, okay? And we have, just like we had with the last will and testament, we want all of our assets to go 50% to Anna, 50% to Mark. And then if one of them were to predecease, we want their share to go to their kids, and so on down the line. The difference between a revocable living trust and the last will and testament is that in this, we have the house that's going to be owned by the trust. Every one of the assets that Joe owns here, the beneficiary on these assets is going to be this trust. So what does that mean? That means when Joe passes away, all of our assets then pour into this trust. Okay? To where all the assets that we have now are owned by the trust, and they're seamlessly going to go to our beneficiaries. Okay? So, in this example, we avoid the entire probate court process altogether. Okay? Because we have all of our assets in this trust. When we pass away, they seamlessly go to their beneficiaries. There is no third-party involvement. It just automatically goes there. What we have after that, so again, there's really two documents. As we get older, okay, and that's the majority of the people that I deal with, is a long-term care planning, elder law, which people have told me that might be offensive term, but elder care, long-term care planning is the majority of what I do. So when it comes to public benefits such as Medicaid or VA benefits, I help people protect their assets. So how we do that is through an irrevocable trust. Now with an irrevocable trust, we have all the same things, Joe's irrevocable trust. The only difference between an irrevocable trust and a revocable trust that I do for asset protection is the trustee, the person that's managing all of those assets, cannot be Joe. again, they can use those assets for his benefit, but he cannot be the trustee or manage those assets. And the reason that is, when I have clients that come into my office that are over 65 years old, 1 out of every 4 Americans have to go into a skilled nursing home at some point in their life. People are living longer now than they ever have in the history of the world. So when it's 1 in every 4, it's not just a chance. At that point, it's a probability, right? So if we're trying to protect all of our assets, our home, our money market account, our IRA, all those things, either for our spouse or for our kids, this might be something we want to look to, right? Because once we transfer everything in there and 5 years go by, our assets are 100% protected. Typical skilled nursing home cost, which I know all of us in here say that's never going to happen, but towards the end of life, sometimes our bodies give out and there's not much we can do. It's $7,500 a month. $7,500 a month times 12 times 3, you're looking at $300,000, $400,000 in cost at that point. So if we transfer it into the irrevocable trust, wait 5 years, then we 100% protected everything that we have in our estate. And again, the biggest difference between the two here is that in the irrevocable trust, we're having to give up some form of ownership of that. But in both of those situations, you're going to avoid the probate court process. So, but again, I use the irrevocable trust or asset protection trust, as we term it, to qualify for VA benefits as well as qualify for Medicaid, where the state of Tennessee would cover the cost of your care.
Which costs more, going through probate or having a trust?
No doubt going through probate. No doubt going through probate. I mean, you're going to spend, I know my charge on that is at least, $5,000, $5,500, and it really just depends on the time the attorney spends on it. And it varies from attorney to attorney, but with probate court, you're going to have filing fee and court costs as well as the attorney's fee. And attorneys charge for time. So, when you go through that, it's just a timely process. Any other questions? So the living trust is, a lot of times that's referred to as just a revocable living trust. Yeah. So when we think of this, I'm a very simple man, and I think of it in very simple terms. Here, the biggest difference between the two right here is what? We just avoid the probate court process. That's what we're doing. So that's why you'd want to use this. With the irrevocable trust, we have the added asset protection, meaning that we can qualify for benefits like Medicaid, and if our spouse goes into a nursing home, we don't have to worry about losing all of our money. Again, at $7,500 of cost in a skilled nursing home, we don't have that worry. If we transfer it into there and wait 5 years, that's the biggest difference between these two right here.
Do you have both? Do you have a revocable and irrevocable, different assets and different things?
Yes and no. So what I do in those situations, if let's just say that we have $500,000, $250,000 in an IRA that we don't want to really put that into the trust, in the irrevocable trust. We want to just make distributions.
Right.
In a situation like that, I would put the beneficiary as the beneficiary of the IRA as the irrevocable trust. That way, it's still coming to us as we want it to, and the house and maybe other assets that we know we're not going to touch, but we want to protect, put that into the irrevocable trust, to where the owner of it would actually be the irrevocable trust. So it's kind of both of those, yeah.
If you have your child's name on, say, your brokerage account and your bank account, how does that affect things?
So you mean as a beneficiary?
No, as
Yeah, so, I mean, if you have them as co-signer, so we say, let's just say a checking account. We have $200,000 in a checking account. That's going to be fine when it comes to them passing away, maybe. And I say maybe because when it comes to the asset protection side of it, we're not going to have that. So if we have to go into a nursing home, we have to spend that down. It's not going to help with things. And once you pass away, if your son is still alive, then that money's going to go straight to your son, right? There's two problems with that. One, what if he predeceases you? What then? Two, if you're wanting that to go to your estate, that's not going to go to your estate. It's going to go to your son's estate, because your son now is the owner of that account. So it's not going to go according to your last will and testament or according to your trust. It's his money at that point, which could be fine, if he's the sole beneficiary and you want things to go according to his estate. But we're not going to have that added asset protection on that. Any other questions?
A CD with payable upon death to one of your children, it goes directly to them, it wouldn't go to the probate, would it?
Correct. But the reason, I would guard against that is because life doesn't always go as we think it's going to go. That your sons are going to, be alive when you pass away. If something happens to one of your sons and we have $250,000 in a CD and they're the beneficiaries of, that's not necessarily going to go to their estate if that's how you want it, or it's not going to go equally to the other people. And when you have these documents, you're planning for contingencies. Things that if it happens, that we know we can encompass that in the documents that we're drafting.
Is it beneficial to put a POD to my son's name on our checking account, cashing account, so when I pass away, they have immediate access to the money without going to court?
I think yes and no. So again, it just depends on what we're trying to do. If we just attacked it with putting PODs on things, I would put as many contingencies as possible, because if you want your assets to go to more than just your son, or when your son passes away, you want it to go to somebody else, again, you just have to put a lot of PODs on things to plan for those contingencies, if that makes any sense. And without knowing your specific situation, I can't necessarily say that would be the best thing to do or not the best thing to do. Because it's really, every situation is completely different on whether I would say, I had somebody came into my office, and I'll be done quickly after this, but had somebody come to my office 2 months ago. She had $15,000 and in a Regions checking account, and she had her adult son as the only person in her life that was her beneficiary. And at that point, I'm going to say, she really didn't even necessarily have to do a trust. We can do, or not a trust, a last will and testament. We can do that, but put your son as beneficiary on the Regions account. In that situation, there's really no problem or anything else we're going to have to necessarily deal with. But everything is dependent upon your situation. And I don't know your situation until I sit down with you and get all the facts on it, because every situation is completely different.
So that person with the $15,000 in the checking account that has a joint account with her son, if she dies, then the son has to write checks and everything, and there's nothing to go into the estate. There's no estate to deal with or anything.
Well, in that, if she doesn't have a house or personal property or real property, then yes. But again, I mean, that is a very isolated situation. Most times, when I'm talking to people, dealing with them, they don't want to do documents and then say that, well, my son still, or my daughter, whoever it is, has to go through, the probate court process, even to a limited amount of transferring real property to son or daughter. So, I mean, because obviously when we're getting estate planning done, we're just trying to simplify our assets in the estate for the people that we love. I mean, I always say it's taking care of the people that you love when you're not here, right? And protecting your assets, because Medicaid, VA, and the government, I'll go ahead and say the suspense, they're not looking out for your best interest on that. They don't care what happens with your assets. I do want to, real quick, do I have like 5 more minutes or couple minutes? Okay. What I did want to address too is, again, these are after really we passed away, when those things come into effect, of what at least these two are. And again, we're covering a lot of information. I do have a free consultation if you want to sit down further about it. But during your lifetime, the documents that you need to have as well: financial durable power of attorney, healthcare durable power of attorney, living will. And so what these are: financial durable power of attorney, you're nominating somebody to make all the financial decisions for you should you not be able to do that. Healthcare durable power of attorney, you're nominating somebody to make all the healthcare decisions for you. A living will is a medical directive. I can't tell you how many people come to my office and say, well, my dad passed away 3 months ago, and I had to be the one that said I wanted, to pull the plug. It's the hardest time in people's life already. making that decision for them so they don't have to make that is extremely important. And again, this is the majority of what I do is long-term care planning. So that's extremely important. I can tell you that from experience. Financial and healthcare power of attorney, you don't have to go through the probate court process, because if we don't have these, me and my wife have both these for each other. If I'm in a comatose state for 6 months and she wants to sell the house, she's not going to be able to do that if she didn't have these documents. She'd have to go through what's called a conservatorship process and go through the Shelby County Probate Court to manage assets on my behalf, because we're joint owners on that house. And because we're joint owners, just even though we're married, it doesn't matter. They want to see that I have authority to make those decisions. These are during your lifetime. These more or less are whenever we pass away. And an irrevocable trust is it's going to go into effect once we do it. Guys, this was a lot of information to shove in 15 minutes, but hopefully...
Is there an expiration on a living will?
No. Well, the expiration, I mean, once you pass away, it ceases to be effective.
My husband had one done in 2008. So do we have to do it again?
No, on something like that, I think you should be fine. On the financial and healthcare power of attorney in 2013, laws changed to where if we have statutory language that's outdated, you probably want to get looked at. But, yeah. Hopefully this was somewhat educational, guys.
Good job.
Well, thank you,
Let
guys.
me ask you this about living will before you go.
Okay.
Because you know, you hear you got to have one, and then you hear you shouldn't have one because your durable power of medical whatever that person should be able to make those decisions since you're not there. Because you could say, well, if I'm unconscious, I want to, don't do anything. And there's a lot of times doctors just make decisions on things that we could be signing our life away when we shouldn't.
Well, I think more times than not, I mean, when it comes to the living will, how it works in practice is there's extremely muddied waters, right? I mean, I can't say that if we're in this state, the doctor's going to utilize that. But I would say that it gives affirmation to the doctor if we're in, because basically what a living will is, if we're in a vegetative state, the doctor doesn't see any chance of survival, we get to nominate whether we want to be placed in artificially provided food, water, or other nourishment, right? So,
See, that's a problem, though. See, because if you're still alive, I mean, you hear about somebody 10 years later waking up out of their vegetative state. They're
Well,
still a human person.
I think at that point then too, then you would sign on the dotted line on the living will that you want to have that.
Well, you don't want to linger forever. I mean, it's every situation is different, and every medical situation is different, and it's got to be taken into account for that situation. And I think some people probably get forced into something they shouldn't have gotten forced into. I don't know. I don't have a living will. I've got the health care thing.
Well, again, though, I think that if it's in that state and the doctor is saying that there's no chance of survival, they don't know everything. But I would rather make that decision than my loved one, and that's just period. And I know there's variables to that, but if you're asking me why I have one, it's because they don't have to make that decision. That if we're in that state where there's 99%, I know there's the 1% that come out of it, but I'll roll with the 99% and take my chances with it.
Well, there is something, I know when we had our living wills done, there's something from the Catholic Church perspective that says how it has to be worded. And it's been a couple of years, so I don't remember the exact wording, but you can have a living will, but you cannot withhold food and water. And there's certain parameters that the church says this is okay and that's not okay.
Yeah, and that can be incorporated into your living will.
Absolutely. It's just,
Yeah.
It's the way it's worded.
Yeah,
Yeah.
no doubt. Well, guys, thank you so much for having me out here tonight. It's been a pleasure.
Which one's the best thing to have, the revocable or irrevocable?
I wish it was that easy.
I know.
It's not, because every situation is dependent upon your current situation. So I wouldn't know that unless I sat down with you and talked to you.